So thank you everybody for joining us today. My name is Jie Huang. I am a senior associate at Scott Legal PC. Today, we're going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm. This means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family matter, employment matter, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series. We are doing at least 2 webinars a month on different immigration law-related topics. And at the end of this webinar, we will send out a few things to all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar. Second, we will send you a comprehensive visa guide, an ebook that you can use as a reference for all of the visa categories that we'll be talking about today. We will also send you a link that you can follow to sign up for any additional upcoming webinars in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe to our YouTube channel and hit the notification button, as we regularly do upload various immigration law related videos that could be helpful for you. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case further. So today we are very lucky to have Kelly Weiner, managing attorney of the firm, with a wealth of experience handling the visa categories that we will be talking about today, who will be presenting about these various options available to extraordinary ability individuals and the requirements and considerations. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, GA. Perfect. So we're going to get started just by talking about some of the main extraordinary ability visa categories. So we're going to talk first about the temporary categories and then also some green card options. With the green card, you're allowed to permanently live and work in the United States. So that provides kind of more flexibility for people that want to stay in the U.S. long term. So first, the O-1A visa. So this is a temporary non-immigrant visa that's available for individuals with extraordinary ability in the sciences, education, business, or athletics. And it has a very high standard to qualify for this visa. You need to demonstrate that you are someone who is one of the small percentage who've risen to the very top of the field, so very top of their profession. For the O-1B, this is another temporary non-immigrant visa, and this is for people with extraordinary ability in the arts, and then also for motion picture or television industry extraordinary ability professionals. The standard for the arts is lower than that for the O-1A. So the standard is the person has to have achieved distinction, which is defined as a high level of achievement, evidenced by a degree of skill and recognition substantially above that ordinarily encountered. So in certain circumstances, especially with kind of newer fields or emerging fields, there may sometimes be an option, of whether you go for O-1A or O-1B if it's not fully clear whether or not the, the category falls into, sciences, education, business, athletics, or art. So, for example, tattoo artists is one, that's kind of potentially could be classified in either way. But if you do have that ability, very often it's favorable to go with the O-1B because it does have this slightly lower standard and can make it easier to meet than for the O-1A. And then there's a separate standard that's available for motion picture and the television industry. This is a bit higher than distinction. You have to show you've reached a level of acclaim substantially above that of his or her peers. So as I mentioned, those two are temporary visas. So that means that when you're submitting your application, you would include an itinerary or an employment contract that outlines what extraordinary ability work you have lined up and for how long. We'll talk a little bit more about timelines later, but generally the O-1A or O-1B can be granted initially for 3 years, can be extended in increments of 1 year. But if you have kind of a new itinerary or a new employer or a new set of projects with the same employer, may be able to get an additional 3 years. So let's talk a little bit about the EB-1A green card. So this is many times when people are thinking about coming to the US, I think about kind of a path through a temporary, visa through to a permanent option. So very often people who are on the O-1A or O-1B will think about the EB-1A as an option for them, coming from an extraordinary ability, temporary visa to the category for a green card that's based on extraordinary ability. So for the EB-1A, it's combined, it's sciences, arts, education, business, and athletics. So there's not a separation between arts as there is with the O-1A and the O-1B. And the standard is very high. So the standard is that you are an individual who has risen to the very top of your field of endeavor. You can demonstrate sustained national or international acclaim. Your achievements have been recognized in your field of expertise, and you're coming to the U.S. to be working in your area of extraordinary ability. So for the O-1A and O-1B, you're kind of showing an itinerary for a fixed period of time. For the EB-1A, you're usually including kind of a statement describing, what it is that you plan to do in the U.S. on a more long-term basis, perhaps, supported by some objective evidence if you have that at that point. So those are kind of an overview of these three, categories in the extraordinary ability arena. Let's talk a little bit now about the O-1A specifically. So for the O-1A, you have to demonstrate either receipt of a major internationally recognized award, a Nobel Prize, a Pulitzer Prize, or much more commonly, people are going to show evidence of at least 3 of the following criteria. Receipt of prizes or awards, membership in associations, which require outstanding achievements, published material about you or your work, original contributions to your field, authorship of scholarly articles, high salary, participation on a panel, employment in a critical or essential capacity for organizations that have a distinguished reputation. And then if none of these, or if perhaps the area that you're in is really niche or really new, if there's other comparable evidence, you can try to include that as well. But you would need to demonstrate that these, pieces of evidence are kind of not available or not relevant within your field. So these are really, when you think about what evidence you're submitting, you want to make sure that you are actually submitting evidence that is, a high quality, that's going to demonstrate that you are someone who has, extraordinary ability in your area. So we'll talk a little bit more about this standard later in the presentation. But when you're thinking about, prizes or awards, memberships, things like that, you want to think not just, am I a member of a professional organization, but also, am I a member of a professional organization, and does it demand outstanding achievements of its members? And what did I have to do to be allowed to join this organization? If it's just an organization that any professional in your field can join, so for example, there's many bar associations. If you are a licensed lawyer in that state, you can pay a fee and join. That's not good evidence for something like the O-1A. It really needs to be a membership in an organization that perhaps requires some type of accomplishment in order to join, or they've reached out to you, or they have stringent criteria about what you have to have accomplished in your area in order to join. So you want to be thinking about that when you're putting together your profile for this type of application. You do want to think broadly about what have you accomplished in your career and what can you demonstrate, but you don't want to include things that might diminish what your profile looks like. So for example, if you've received a lot of student awards, those types of things are not going to be helpful for these types of applications. Let's move to talk about the O-1B visa. So you can see, quite similar in the way that it's structured. So either you've won a significant award, in the arts or motion picture television industry, an Emmy, a Grammy, or you meet at least 3 of the following criteria. And as you can see from the list here, these criteria are more focused on what would be relevant for a professional in the arts, or a professional in the TV or motion picture industry. So the focus is more on kind of lead starring or critical roles for organizations, productions, or events, any critically acclaimed success. So all those things are going to be more focused on the arts. And then similar to O-1A, also other comparable evidence, although this category is not available for people in the motion picture industry. Let's look a little bit more at the differences between the O-1A and the O-1B. So as we've identified, O1A is for sciences, education, business, or athletics. O1B is focused on the arts, motion picture, and television industry. The standards are slightly different between each. So the O1A is a small percentage who have risen to the very top of their field. Arts is going to be distinction, so a high level of achievement, but generally an easier standard to meet than the O1A. And then the motion picture and television, will have its own standard of a level of acclaim substantially above that of their peers. The length of issuance is the same for O1A or O1B, so you can initially get that visa for 3 years and then get extensions, of if you're just continuing the same set of projects, you need more time on your itinerary. The extension is going to be for 1 year. However, if you do have a new itinerary of projects, if you have changed your employer, if you have a new employment agreement with a new, set of work that you're doing, sometimes the government will accept that and allow you to be granted an extension for 3 years as opposed to just 1 year. Also a common question, can family members join you? So yes, family members can get O3 visas. That includes spouses and unmarried children under 21. They cannot work in the United States, but they can remain in the United States with you and can attend school. So now we're going to talk a little bit about the EB-1A green card. So we haven't listed out the requirements because they are very similar to the O1A and O1B. So it's either receipt of a major internationally recognized award or meeting 3 out of 10 criteria. The criteria essentially mimic the O1A and O1B criteria with a little deviation to encompass both, business, education, athletics, and arts as well. An important thing about any extraordinary ability petition, but particularly for the EB-1A category, is that you're basically going through a 2-step analysis. So one is, did you meet the plain language of the criteria? So have you submitted evidence that you've received prizes or awards in your field of endeavor? Internationally recognized or nationally recognized prizes and awards. And then in the second step, they're going to consider the quality of your evidence. So they're going to look at your case and all the evidence that you've submitted, and then make a determination as to whether or not that shows, based on the totality of circumstances, that you should be considered someone who's risen to the very top of your field of expertise. So that's where you do want to be thoughtful about the information that you're including. You don't want to include things that are going to lessen or diminish your profile or make them feel that you're padding the application, things like student awards or maybe working for small companies that won't be considered distinguished, or maybe for example, if you were an intern at a company, even if it was a very distinguished company, that's not going to be helpful to include because you're not going to be able to show that you had a leading or critical role in that company as just an intern. So you do want to be thoughtful about what information you're including to make sure that everything that's being included is helping to build up that profile so that you not only show that you meet the plain language of the regulatory criteria, but that you also are going to meet this second step analysis where they look at your profile in totality to determine, are you someone who's risen, to the very top of your field, of endeavor. Another thing to consider about the EB-1A is just that it's not a guarantee in any way that you would get the EB-1A just because you were granted an O1A or an O1B. In particular for the O1B, because it does have that lower standard, making the jump from, O1B to EB-1A can be a larger jump. But even for an O1A, just because you qualify for an O1A does not mean that you are automatically going to qualify for an EB-1A. So if you have an O1A and it's something where you are interested in transitioning to an EB-1A, it's a good idea to talk to an attorney to understand, where is my profile at? Am I already at the EB-1A point, or should I spend some time, while I'm here on the O1A, helping to build that profile, helping to create, more of the evidence that would help me in my application? Because there are certain things that you can do to build your profile. Perhaps you wouldn't focus necessarily on publishing in your field, but because you are eyeing the EB-1A, perhaps as opportunities come your way, you take advantage of those things because it will help build your profile in a way that could get you to the EB-1A level. So you do want to be thinking strategically if the EB-1A is a goal, because it is a difficult category and is really meant only for people who have reached the very top of their field and can demonstrate that through significant evidence. There are other categories, and Jay is going to talk about one particularly favorable category right now, in a green card category for the National Interest Waiver, which can sometimes be a good option for people that are on, the extraordinary ability path, but maybe haven't quite gotten to the EB-1A level yet. So I will turn it over to her to talk about that.
All right, thank you, Kelly. Yeah, so let's discuss the EB-2 National Interest Waiver, which is a green card pathway. So to qualify for the National Interest Waiver green card pathway, first, every applicant needs to meet the EB-2 threshold requirement. And that is the minimum before even getting to the National Interest Waiver three-prong test, as I will talk about in a bit. So the threshold requirement, you can meet it in either one of two ways. So the first way is to show that you have an advanced degree defined as a master's degree or higher, such as a PhD. Degrees such as an MD or a JD that requires a bachelor's for admission also counts as an advanced degree. Or show the equivalent, show that you have an equivalent of an advanced degree, which can be shown by showing that you have a bachelor's degree in your field plus 5 or more years of progressive work experience in your field after you have earned your bachelor's. And what does progressive work experience mean? It just means that your job duties and your seniority and your responsibilities did not stay the same over these years that you've worked, but those duties and responsibilities changed in complexity and seniority over time. So you do need to show that progression in order to show 5 or plus years of progressive work experience. Now, if you don't have a bachelor's, or if you don't have a bachelor's plus 5 years, or if you don't have a master's degree, there is another way you can qualify under the EB-2 category, the threshold requirement, which is by showing exceptional ability. And it is important to note that exceptional ability is very different from extraordinary ability, which is the concept that we have been talking about in the O-1 and EB-1 context. Exceptional ability is defined as a degree of expertise that is significantly above what is ordinarily encountered in the field. So although it requires a degree of showing that you excel above others, it does not require you to show that you have received sustained national or international acclaim to the degree of being the top 1% of your field. So it is a significantly lower standard to meet. Now, how do you meet the exceptional ability criteria? You need to show that you can provide evidence under at least 3 out of the 7 criteria that we listed here, including, for example, having any degree from a program that is related to your field, having a license to practice in your field, having at least 10 years of full-time work experience in your field, and evidence that you have earned recognition for your achievements in your field by your peers, industry, government actors, etc. And there are many ways you can prove this, for example, by showing that you have authored publications in your field in academic journals. If you have made inventions that have been patented, for example, those could also be used in support of your achievements that have been recognized by various actors in your field as significant. So let's say that then, assuming that you have met the EB-2 criteria, either by showing that you have an advanced degree or either by showing that you have exceptional ability in your field, the next step is to show that you and your work qualifies for the National Interest Waiver. So what is National Interest Waiver? So normally, if you are applying for a green card under the EB-2 employment petition category, usually you have a sponsor. Usually you have a U.S. company that is sponsoring you with a job offer, and there is a process called a labor certification, which is really the employer tests the labor market in the United States to show that there is no other worker in the U.S. Qualified and willing to do the work for that particular job. And that can, usually take a long time to process, and that can be a barrier for many to apply for a green card, and it means you can't really self-petition for a green card. However, if you qualify for the National Interest Waiver, that means you can actually self-petition for a green card. It puts that option open to people. So in order to show that you qualify for the NIW, there are additional requirements that you should meet. So what are these 3 prongs? The first prong is that your endeavor in the United States has substantial merit and national importance. And what does that mean? Substantial merit can be shown in a wide variety of fields, including business, health, education, science, and technology, and endeavors that further human knowledge in those key areas, such as medical advances, improvements in engineering, for example, are likely to qualify as endeavors of substantial merit. For national importance, one thing that is very positive is to show a strong economic impact that can result from your endeavor in the United States. So the question that you really want to ask while you're preparing for the NIW is, what is the future impact of my work in the United States, and how is that important to the United States? And usually, what is also helpful is if you pull government reports and executive orders and other evidence from government and industry actors showing why a particular area is important to the United States, and really linking it with your endeavor and showing how your work in the United States have the potential to introduce advancements in those critical areas. The second prong, the second criteria in meeting the National Interest Waiver, is showing that you yourself are well positioned to advance the endeavor of national importance and substantial merit. And so in this inquiry, the focus is on the individual themselves. You really want to showcase your education, your relevant experience, and provide sufficient evidence that you have a record of success in previous related projects that position you well to continue this impactful work in the United States. And finally, the third criteria to meet is, on balance, it would be beneficial to the United States to waive the requirements of a labor certification for your particular case, right? And there are multiple ways you can strategize this prong. One strategy is to emphasize prong one on the broad systemic benefits that your work can have to your field as a whole, the importance of your work to the United States governmental interests, for example. You can also talk about how your strengths regarding prong two, how you're very well positioned to advance your endeavor. For example, if you have unique know-how and experience that other U.S. workers with minimum qualifications do not have, that can also be a positive factor for the third prong. Finally, there could be special considerations you can emphasize in meeting the third prong. For example, if you're an entrepreneur and if your project in the United States will end up creating significant number of U.S. jobs and creating tax revenues and result in positive economic impact to that region as a whole, that can be another strengthening factor you can emphasize in meeting the third prong. All right, so to shift gears a little bit, let's talk a little bit about expert opinion letters. Expert opinion letters are an important part of both an extraordinary ability petition or an NIW petition for many reasons. So the purpose of these expert letters are that for the EB-1A and O-1A, for example, you would want the expert letters to provide enough detail and examples to confirm how you have extraordinary ability in your field and how well known you are in your field, and really showcase the achievements that you have made in the past in your field that have made a significant impact, that position you in that small category of professionals that have really shown outstanding performance. Regarding the NIW application, you would want the expert letters to really talk about the potential impact of your proposed endeavor in the United States, right? So, for example, if you get a letter from an interested government agency, that can be a very strong strengthening factor for your application. And also, you can get other letters, other types of letters that confirm your record of success in the field in support of the second prong that we just talked about, well positioned to advance the endeavor. For example, letters from previous employers confirming your leading role in a particular project that resulted in a significant impact to your field as a whole, such as development of new technologies that were commercialized broadly, or research projects that received a lot of attention from other peer experts. Finally, another type of letter that can help an NIW application for a business entrepreneur, for example, is a letter from an economist who can write a report on the prospective economic impact and the direct and indirect job creation that can be expected from the person's work, prospective work in the United States. So another important aspect is who is writing a letter. And ideally, because of the nature of these extraordinary ability petitions, you really want to get letters from leading experts in the field who have decades of experience. Usually we would add a full curriculum vitae in addition to the letter itself. And usually those experts consist of individuals who are in senior positions in leading institutions in the industry or in government. For the O-1A and EB-1A, you really want the experts themselves to already have this sustained national or international acclaim to be able to speak about the applicant's achievements in the industry with authority. For the NIW, one very positive aspect can be to get a letter from an expert who is working in affiliation with a government agency. So for example, if you're working in agriculture, getting a letter from the USDA, for example, could be a very helpful push to your petition. So another thing that the letter should contain is an explanation of how the individual expert knows you. So we do recommend having a mix of independent and inner circle experts. So independent experts mean that people who haven't directly worked with you in the past, but they know you through your work or through your outstanding reputation in the industry, right? And they can confirm that your abilities are truly outstanding in the field, or that your work stands to impact the field in a broad way in the future. By contrast, inner circle experts are people who have worked with you in the past. And those letters can be helpful because they can speak in detail about your achievements in the past, the projects that you have completed in the past, and also talk about the impact of those projects in detail. And detailed examples are very important because it really fleshes out the nature of your abilities and the impact of your work for the USCIS officer. Discussion of your work, recognitions, accomplishments, achievements. So as I just mentioned now, specificity is very important in those expert letters. Letters that are formulaic and simply repeat the regulatory requirements are not very effective. For example, if a letter just says, oh, the applicant is a well-known figure without going further detail into explaining how they are well-known and for what they're well-known for, those letters will not be as effective. So it is very important to include specific examples of your work because those examples will support why you have extraordinary ability in your field or why your project has national importance in the NIW context. All right, so let's shift gears then now and talk a little bit about the strategic considerations on what category to choose among those various options we talked about in this presentation. So the first question to consider is, do I want to stay in the United States temporarily or permanently? So the O-1A and O-1B, as we spoke about earlier, are non-immigrant visas. And although you can continue to renew those visas, they are temporary visas to the United States. And one advantage is that they are faster to get. So if you become a permanent resident of the United States, the expectation is that you will reside permanently in the United States. And there are requirements such as physical residence requirements if you become a green card holder, and there could also be tax responsibilities such as filing tax returns, which you definitely want to look into before you're looking into all of these options. So if you want to continue to travel in and out of the United States, for example, if you want to have your permanent residence in a foreign country and come in the United States temporarily to work, the O-1A, O-1B could be a great option for you. As opposed to that, the EB-1A and NIW are both green card categories, and really they are best suited for people who do want to live in the United States on a permanent basis. Also, once you get the green card through the EB-1A or NIW pathways, eventually this can lead to citizenship. So if that is one of the goals that you have, certainly this is a great option for that. Another question to consider is, do you have a U.S. employer or agent, a U.S. person who can act as an agent, or do you want to self-petition? So both the O1A, O1B, that is a visa category that requires a U.S. employer or U.S. agent. And what does that mean? A U.S. employer means a company, U.S. entity in the United States that will provide you with a job offer. Now, I believe there was a question that came in regarding, do I need to have a job offer for an O visa? Is there a way I can freelance in the United States or work on a consulting basis with this visa? Well, one idea that could work is if you have your own company, for example, a consulting firm that you own, for example, that U.S. entity that you set up can be considered a separate legal entity from yourself. So that U.S. company can act as the petitioner for the O1 visa. And if you, for example, if you get consulting arrangements and get contracts through that U.S. entity, that can be the basis of your O1 petition. So certainly that is an option for entrepreneurs to consider if they are considering using the O1 category. As opposed to this, the EB-1A and NIW, the foreign national themselves can be the petitioner, the self-petitioner for the petition itself. So there was another question that came in. Can you apply for the EB-1A petition directly? And the answer to that is yes. So even if you live and work in a foreign country and you have never had any ties to the United States, you can still submit yourself the EB-1A petition without having had another visa in the United States. You can certainly go directly to that route. All right, so the other consideration that could be important are family considerations. As we spoke about this before, the O3 visa is available for spouses and children under 21 for holders of O1 visas, but work authorization is not available for those on O3 visas. As opposed to that, for the EB-1A and NIW, those are both green cards. And if you have spouses and children under 21, those dependents can also apply for and receive green cards as dependents. So that can be a significant advantage for some people. All right, so then now let's talk a little bit in more detail about considerations when you already are in a non-immigrant visa status, but you want to move to a green card in the future. So we talked a little bit about this before in previous slides, but the EB-1A uses a higher standard qualitatively as opposed to the O1A or O1B. And particularly, it could be a big jump from an O1B to an EB-1A because the language used for judging the qualifications are very different. So it is very important to note that qualifying for the O1A and O1B does not mean that you automatically qualify for the EB-1A, which is really reserved for the professionals who are at the very, very top of their fields. If you are already on an O1 visa and you would like to get an attorney's opinion on whether the profile is strong for the EB-1A, definitely reach out to us. We'll be happy to evaluate your profile. And as Kelly mentioned earlier, one strategy could be, while you're on the O1A, focus on strengthening your profile and collecting evidence that could be the most advantageous for eventual EB-1 petition down the road. Timing is another important issue to think about. So if you have an underlying visa, for example, think about when you want to file for an immigrant petition. If you're considering an EB-1A or an NIW petition, those are both immigrant petitions. Think about when your non-immigrant visa ends to really think about the timing. Because non-immigrant intent is an important consideration for renewing many types of visas. So if you're on a TN visa, for example, the TN visa is one category where non-immigrant intent is very strictly scrutinized. So if you go ahead and file an I-140, an EB-1A petition or an NIW petition, that record could pose risks for you renewing your TN visa in the future or applying for a new TN visa because non-immigrant intent is such an important part of that. Similarly, a B1, B2 visa, for example, an F visa, for example, those are visas where non-immigrant intent are strictly scrutinized. Now, dual intent visas are not affected by a filing of an I-140. So, for example, the H-1B visa and L visa, and also the O-1 to some extent, are usually okay, even if you have filed an I-140 before that. Definitely speak to an attorney regarding those questions if you are thinking of extending or renewing your underlying visa status, and also considering applying for an I-140, because the timing could be an important issue here. Okay, the last thing you want to consider is family. So, for example, if you have children that would also benefit from a dependent green card, it may be beneficial to file early enough to avoid aging out, the child aging out by turning 21. All right, so the last topic we will talk about is whether extraordinary ability categories are available for entrepreneurs, and the answer is yes. The EB-1A and NIW both allow for self-petitions, as I mentioned before, meaning that both are possible options for entrepreneurs. In addition, there has been changes in the NIW National Interest Waiver standard under the now prevailing case law, matter of Denisar, which made NIW a much friendlier category for entrepreneurs. For example, if you can show that your prospective endeavor in the United States would have substantial positive impact economically by creating a high number of U.S. jobs, by creating tax revenues, and spurring economic ability, economic productivity, and results in advances in technology or things like that. All of those things can be positive strengthening factors for an NIW case. Another thing that we would like to emphasize is that it is possible to apply for an O-1A as an entrepreneur. You must have a separate corporate entity that can act as a petitioner. As I mentioned before, you can set up a company that you own that will act, and it must be a U.S. company. It cannot be a foreign company. But as long as you have that structure, it is possible for an entrepreneur to proceed with the O-1A route as well. All right, so let's turn to questions and answers. I don't believe there has been any other questions that came in as of now. All right, so if there are no longer questions, we can close here. Thank you, everyone, for participating in the webinar today. Okay, we just have one other question that just came in. What are the timelines? Not sure which timelines this question is referring to, but if we're talking about the processing times, for the O-1, you can, if you use the premium processing option, the I-129 can be approved within 15 days. Processing times for NIW, okay. So for the NIW, there is a premium processing option available for the I-140. So you can get an answer, either an approval, a request for evidence, or an NOID within 45 calendar days if you pay extra. For regular processing, it usually takes about a year for the I-140 portion. And for the EB-1A, there is also a premium processing option. You can get an answer from the government within 15 calendar days if you premium process. High salary is one of the conditions for EB-2 NIW. High salary, I'm not sure if that's one of the that eligibility criteria for the NIW. However, that is one of the criteria that can be used in support for an EB-1A. How soon can an EB-1A or NIW be granted in the Toronto consulate? So first, you would apply for the I-140 petition to be approved, and the timelines about that, I have already talked about this. And once you have the approval, then you would go through the immigrant visa processing processing through the National Visa Center, and that can typically take about a year to process. I don't have specific data for Toronto, and usually it will be Montreal if it's an immigrant visa, actually. But you can expect at least around a year that you would be spent processing the immigrant visa.
Processing times for immigrant visas are a bit, up in the air right now as well, just because, for example, for EB-1, there's, dates are current, but for EB-2, there's a backlog, which
Right.
means that there's, even if you get your I-140 approval and your case is sent to the National Visa Center and they approve all the documents, even within a few months, then it could just kind of be sent to the consulate and be waiting there, while they wait for immigrant visas to become available. Also in Montreal, the employment-based cases are quite backlogged. I believe they're processing cases from 2022. So they, are working on catching up from the backlog from COVID, but still quite backlogged on immigrant visa processing. Sometimes it can be, depending on your circumstances, it can be, better option to, get a temporary visa, and potentially try to adjust status from within the United States. Sometimes you can file your green card application even before an immigrant visa is available and file for work and travel authorization with that. So it's definitely an important strategy thing to discuss, with your attorney in terms of long range planning for a green card.
Yeah, thank you, Kelly. So yeah, going for the O-1 could be definitely a faster option to get to the United States. Right. So I think there's one question regarding having a job offer for an O-1 visa. Can I freelance, or the things that you recommend to enhance my chances? So yeah, definitely set up a consultation with us so that we can really take a look at your profile in depth and we'll be able to give you some recommendations. Press releases definitely could help. There could be a variety of strategies you can take to improve your chances. So definitely reach out to us for that. Let's see. For award-winning projects, should you have been a key member to qualify for awards. For EB-1A, it says employers winning the award does not qualify. So that is true. So you need to have had a critical role in that award. And it is ideal if you are one of the named members of the award. So if it's an employer award and you were one of the thousands of people who worked in that company, then that would likely not be able to be used for the EB-1A evidence. There should be a way to tie you in as a key member of that particular achievement. If you're a member of a team and your team won the award, and if you can get an expert letter that shows that you were one of the few, let's say like 4 to 5 members who worked on that, and they can show how critical your role was, that can definitely be a possibility to be used in support of the EB-1A. Minimum citation threshold going for O-1 EB-1A. We don't really use a minimum citation threshold, unfortunately. We use a tailored strategy for each client depending on their profiles. So we don't really use a number. We have had approvals for O-1, for example, with a very low citation threshold and sometimes with no citations at all. But it definitely depends on the case and the profile. Definitely reach out to us and we will help you take a look at your case. I'm not sure regarding when the EB-1A priority dates will improve, unfortunately.
Yeah, I mean, I'd say, unlikely that there will be significant improvement. Obviously something, continuing to monitor on a month-by-month basis. But there are backlogs in many categories, particularly, unfortunately, for individuals born in India and China. And I think we can expect that to continue as it has in years past.
All right. Well, thanks everyone for your active participation. It was a pleasure. Thank you, Kelly, for sharing your expertise, and I hope everyone has a great day.